The United States government is currently sitting on more than 350 million pages of classified documents that are legally overdue for release. 350 million pages. That number isn't speculation. It comes directly from the National Archives and Records Administration's own internal assessments. And here's what makes that staggering. Many of those documents were supposed to be declassified decades ago. Some of them date back to the Eisenhower administration, some to Truman. A handful stretch back to World War II. The official story is that these delays exist to protect national security. But what the archivists, the FOIA officers, and the former intelligence officials will tell you, when they're willing to talk, is that the reality is far more complicated and far more troubling. To understand why secrets take 50 years or more to surface, you first have to understand the system that's supposed to release them. The current framework governing declassification traces back to President Truman's Executive Order 10290, signed in 1951. That order created the first standardized classification system for the entire federal government. Before that, individual agencies essentially classified whatever they wanted, whenever they wanted, with no uniform standard and no coherent plan for ever releasing anything. Sound familiar? Because experts who study this system will tell you that in many ways we've never really escaped that original chaos. Today, the system is governed primarily by Executive Order 13526, signed by President Obama in 2009. That order established what is supposed to be a mandatory review cycle. Under that framework, most classified documents are supposed to be automatically declassified after 25 years. 25 years, not 50. Not 75, 25. So why are we talking about documents that have been buried for 50, 60, even 70 years? The answer lies in the exceptions. And there are so many exceptions that the rule has effectively become the exception. There are currently 9 categories of information that can delay or permanently block automatic declassification. These include information that would reveal intelligence sources and methods, information that would reveal the identity of a confidential human source, information that would reveal key design concepts of nuclear weapons. So far, that sounds reasonable. Nobody wants to burn a source. Nobody wants nuclear designs floating around. But the exemptions don't stop there. There are also exemptions for information that would cause serious damage to foreign relations, information that would reveal vulnerabilities in critical infrastructure. And here's where it gets interesting. There's an exemption for information the originating agency simply hasn't reviewed yet. That last one. Let that sink in. A document can be kept classified not because it's dangerous to release, but because nobody has gotten around to looking at it. In 2021, the Information Security Oversight Office, the federal watchdog responsible for monitoring the classification system, published a report that should have made front-page news. It documented that the federal government had created over 1.9 million new classification decisions in a single year. At the same time, less than 200,000 pages were being declassified on an annual basis through the automatic review process. Do that math. New secrets are being created at nearly 10 times the rate that old ones are being released. This is the backlog that archivists talk about in hushed tones, because it means the pile isn't getting smaller. It's getting dramatically, almost incomprehensibly larger every single year. A senior archivist at the National Archives who spoke with researchers working on declassification policy described it this way, and this quote has been confirmed in multiple academic papers on the subject. We don't have a declassification system. We have a declassification lottery. Most things stay buried not because someone decided they should, but because no one ever decided anything at all. To understand the mechanics of how this lottery actually works, you need to understand the specific journey a document takes when someone requests its release. It typically starts with a Freedom of Information Act request. The FOIA was signed into law by President Lyndon Johnson in 1966. Johnson reportedly hated it and only signed it because Congress left him no choice. The moment you submit a FOIA request, a clock is supposed to start ticking. Federal agencies are legally required to respond within 20 business days. In practice, the average FOIA response time in 2023 was over 400 days. Some requests have been pending for over a decade. The CIA's FOIA backlog alone, as of their most recent annual report, contained over 10,000 pending requests. The backlog isn't just a paper problem, it's a people problem. The declassification workforce across the federal government numbers fewer than 3,000 people. These are the analysts, the reviewers, the archivists who actually sit down with a document, read it, and make the call, safe to release or not. 3,000 people, to clear 350 million pages. If every one of those employees did nothing but review documents, 8 hours a day, 5 days a week, with no backlog growth whatsoever, it would take over a century to clear the current queue. But it's actually worse than that, because those reviewers don't just read and stamp, they have to navigate what's called the equity system. Here's what the equity system means in practice. When a CIA field report from 1970 gets flagged for review, that report might reference operations coordinated with the State Department, the Defense Intelligence Agency, the NSA, and 2 foreign allied governments. Every single one of those entities has what's called an equity in that document, a stake in what gets released, and every single one of them has to sign off before the document can be released. A former FOIA officer who spent 15 years processing requests at a major intelligence agency described what happens next in testimony before the House Oversight Committee. She explained that in a typical complex case, the reviewing agency sends referrals, essentially requests for consultation, to every other agency with an equity. Those referrals can sit in another agency's queue for months, sometimes years. The receiving agency may have only one person assigned to handle all incoming referrals. That person might be handling referrals from a dozen other agencies simultaneously. And if that person leaves the job, if they retire or transfer or simply quit, the referrals can sit completely untouched until a replacement is hired and trained, which can take 6 months to a year. This isn't conspiracy. It isn't deliberate suppression in most cases. It's a system that was designed without any serious infrastructure for actually getting things out. But sometimes it is deliberate, and that's where this story takes a darker turn. There are documented cases, confirmed by multiple independent investigations, where agencies have used the classification system not to protect genuine national security secrets, but to protect themselves. The Church Committee investigations of 1975 and 1976 were the most significant examination of intelligence agency abuses in American history. When investigators began requesting documents, they encountered a pattern that committee staff described in internal memos as strategic delay combined with selective amnesia. Documents that revealed illegal wiretapping operations, assassination plots against foreign leaders, and domestic surveillance programs were not flagged as nationally sensitive. They were flagged as potentially embarrassing. The distinction matters enormously because, under the law, embarrassment is not a valid reason to classify or withhold information. Executive Order 13526, Section 1.7. The current governing framework explicitly prohibits using classification to conceal violations of law, inefficiency, administrative error, or embarrassing information. And yet, the JFK assassination records provide perhaps the most studied example of this phenomenon. Congress passed the President John F. Kennedy Assassination Records Collection Act in 1992. That law mandated that virtually all assassination-related records be released to the public by October 26, 2017. By 1992, 3 decades had already passed. The intelligence officials from 1963 were mostly retired or deceased. The Cold War operations those records might reference were long over. 2017 came and went. Thousands of documents were withheld. The deadline was extended. Then extended again. Documents were still being withheld as recently as 2023, 60 years after the assassination. The reasons given ranged from protecting ongoing intelligence sources, 60 years later, to concerns about revealing liaison relationships with foreign governments that have long since changed or dissolved. Researchers who have studied the specific withheld documents say many of them appear to involve not national security at all, but rather internal CIA and FBI communications about what those agencies knew and when they knew it. In other words, The official argument goes, it may not be that the documents reveal dangerous secrets about the assassination. It may be that they reveal uncomfortable truths about institutional knowledge and institutional failures. If the pace of declassification is troubling, what happened in 2006 should have caused a national outcry. It largely didn't. The National Archives revealed that starting around 1999 and continuing through the mid-2000s, the CIA, the Air Force, and several other agencies had been working with NARA staff to secretly reclassify documents. These were documents that had already been declassified, already been placed in public archives, already been seen by researchers. Some of those documents had been available to the public for more than a decade. The historian Matthew Aid discovered the program when he noticed gaps in archival files he had consulted previously. Documents he had personally handled were simply gone. An audit eventually revealed that over 9,500 documents had been secretly reclassified and removed from public access. The Interagency Security Classification Appeals Panel reviewed a sample of the reclassified documents to determine whether the reclassification had been justified. Their conclusion was striking. More than half of the reclassified documents contained no information that could legitimately justify classification under current standards. They had been removed from public access essentially for no valid legal reason. When the program was exposed, the official response from the agencies involved was not accountability. It was not prosecution. It was, effectively, a request that the public trust that this would not happen again. The same agencies responsible for the reclassification retained authority over their own classification and declassification decisions. Here's something that almost nobody talking about declassification discusses, and it's one of the most significant factors in why the backlog keeps growing. We live in the digital age. The federal government generates classified information digitally, trillions of bytes of it. But the legal framework for declassification was written almost entirely for paper documents. The 25-year automatic declassification window, the one almost no documents actually comply with, was designed around the concept of a physical file being reviewed by a physical person making a physical decision. Digital records present entirely different challenges. A single classified email chain might reference dozens of individuals, dozens of programs, and span 3 or 4 different agency equities, all within a paragraph. Automated review tools exist. Artificial intelligence systems have been piloted by the National Declassification Center specifically to help identify documents that are safe to release. In pilot testing, these systems have shown promise. Some studies suggest AI-assisted review could reduce processing time by as much as 70% on certain document types, but agencies have been extraordinarily reluctant to allow